Hey guys, and welcome to the Working Money Channel. So Stefan Hubert cannot believe it. Watch this. The SEC has taken their disclaimer even further and now even qualify the use of the words we and us. And guess why, guys? Because we called them out on it. So they have actually changed. They've actually altered the statement on their website. And here is the highlight. The statement represents the views of the staff of the Office of the Chief Accountant, or the OCA. It is not a rule, regulation, or statement of the SEC or the Commission. The Commission has neither approved nor disapproved its content. This statement, like all staff statements, has no legal force or effect. It does not alter or amend applicable law, and it creates no new additional obligations for any person. Our and we are used throughout this statement to refer to OCA staff. Boom goes the dynamite. Look at that. XRP community having an effect on the U.S. regulatory body, the SEC. Got to thank Stefan Hubert for pointing that out, and the sources down here if you guys want to check the website out yourself. So we've got some interesting news. A former executive of the SEC, he believes the regulatory body has a good chance of losing its $1.3 billion lawsuit against Ripple on the merits of the case. This brought to us by Michael at Val5Link. So this has to do with Joseph Hall. He recently did an interview, and he believes that the SEC is not yet equipped to handle litigation in cases concerning cryptocurrencies as securities yet, making it hard to win the case against Ripple. And so Joseph Hall, he has some pretty good experience considering he is a former SEC commissioner. He's not the only person that thinks the SEC really doesn't have a leg to stand on. The former executive of the SEC believes the regulator has a good chance of losing its $1.3 billion lawsuit against Ripple on the merits alone. Attorney Joseph Hall also voiced concerns over what the SEC's endgame could be regarding the high-stakes case against Ripple and XRP, which will have ramifications for the entire industry. So that is the other thing we have to be paying attention to. Like I've said on this channel before, this is a landmark case, and this is really going to have an effect on the XRP price. If I bring XRP up right now, it's trading about 73 cents, a little higher than it was yesterday. But guys, this price is suppressed. Of course, XRP and other cryptocurrencies are really just trading in the speculative market at this moment in time. All this movement, everything that we've seen, everything that we've really seen ever, essentially has been based on Bitcoin price movements, and today is no different, right? Even if we just zoom in real quick on the chart here, and we look at it on the hourly, we can see similar moves for XRP as we've seen for BTC. We could see that recent dip down, the recent push back up. So bringing up the XRP chart again, you guys can see similar moves. So everything is basically doing the exact same thing. Bringing up Ethereum as well, you can see that similar dip. Bringing up ADA, similar dip. So at the moment, the spec market is what is controlling the market. And so if we do see something fundamentally different, like regulatory clarity for XRP, which would essentially give that cryptocurrency the regulatory clarity in the United States, it would be one of the only ones, that could see price appreciation really surge. So it will have ramifications for the entire industry. The lawsuit alleges that the company and its co-founders, Brad Garlinghouse and Chris Larson, failed to notify the SEC about its sales of XRP, so we know those details. So back to who's being interviewed here. Joseph Hall, former managing executive for policy at the SEC, appeared on the Thinking Crypto podcast with Tony Edwards on February 22nd, and this is what he said, guys. I'm not entirely sure what the SEC is planning on proving in the XRP litigation. The implications for the SEC and for the crypto industry as a whole are massive. As Hall puts it, the SEC has a lot riding on the case, and their entire regulatory project could basically be shut down if they lose on the merits. So, it sounds to me like they are playing it very fast and loose, considering what's at stake here. So he continues by saying, and I continue to think there is a pretty good chance that the SEC will lose on the merits. Hall believes that Ripple has a strong defense on the basis that the SEC failed to give fair notice of its investigation. The SEC is required to notify individuals and corporations that they are being scrutinized, which is exactly what Ripple had been being by the SEC, and they just were not given that fair notice. I'm very sympathetic to the argument. It's a basic due process argument. The Ripple network was operating for years before the last-minute filing of the lawsuit against them. Another attorney who has been following is Jeremy Hogan, and we do know about Jeremy Hogan's position. I'm going to get to some of the details about some of the updates we've recently received with regards to this lawsuit. So James K Feilin, first of all, just posted this yesterday. SEC files request to file Sir reply regarding motion to strike, citing the SEC versus LBRY decision, or LBRY. I keep forgetting how that company is pronounced, LBRY, decision in which New Hampshire federal judge granted judgment on the pleadings in an unrelated selective enforcement defense. So this is the LBRY decision on the motion for judgment on the pleadings of the selective enforcement defense raised by LBRY in New Hampshire. Wrath of Kahneman saying, wow, they seem adamant about getting this new precedent in, as if it would make a case they've failed to establish so far. So the SEC pushing back, essentially extending the date again, bringing in new evidence from this case. They think the LBRY case is going to help them set a precedent in their case. But is it? Will it? Could it actually help them? Let's go over some of the things we know so far. So John Deaton saying, here is his prediction. The case against Brad Garlinghouse and Chris Larsen is over. It was over the day it was filed. There's no way the SEC can meet its burden. The SEC must prove that the two executives had knowledge XRP was a security or was reckless in not knowing. And so we know, we've been following this for a very long time now, that the crux of Ripple's argument is the fair notice defense, or one of them at least, and we know that they just didn't receive fair notice, even considering how many times they went to the SEC and they said, hey, look, are we doing this right? And the SEC just kind of brushed them off. Continuing John Deaton's thread, in order to prove recklessness, the SEC must prove a reasonable person would have known XRP was a security because it was so clear and obvious to anyone at that time. And we obviously know that isn't the case. Let's review some of the evidence. First, in October of 2012, Perkins Coie memo, it concluded XRP was not a security, so that's a pretty basic one. Number two, until April 2018, the SEC allowed staff, including enforcement lawyers, to trade and own cryptocurrency, including XRP, without any restrictions. Number three, June 18th, 2018, SEC legal memo analyzing whether XRP is a security. SEC enforcement lawyers do not conclude XRP is a security because there's no enforcement recommendation made. Number four, June 14th, 2018, the Hinman speech. Of course, the famous Hinman speech. Hinman said Ethereum is no longer a security because it's sufficiently decentralized. Since it can be argued the XRPL is at least as decentralized, if not more, it's reasonable to believe ongoing sales of XRP from 2018 forward were lawful. And so he's retweeting out Digital Asset Buy's clip here from the Texas Bitcoin Conference. Nancy Wojtas, truth teller and partner at Cooley, which is a law firm, member of the Venture Capital Working Group, who submitted the safe harbor memo to Bill Hinman. There's also Wendy Moore, partner of Perkins Coie. They were talking about it in this clip. I will link this in the description. I'm not going to play the clip right now, but I will link this in the description if you guys want to watch it. Number five, August 20th, 2018. Meeting between Brad Garlinghouse, Joel Katz, who is David Schwartz, with Clayton and Hinman. Brad yells out, Ripple's in purgatory because of the lack of clarity over XRP. And at that time, neither Klinman nor Hinman informed Garlinghouse or Ripple that they or the SEC believe XRP is a security. Also, number six, Coinbase goes to the SEC in January 2019 and informs the SEC it has concluded XRP is not a security and plans on listing XRP the following month. So there was also that. It wasn't only Ripple going to the SEC asking for the clarity. There were other companies, clearly, that wanted to be able to list at that time in the top five, one of the most popular cryptocurrencies there were in the market. And still, the SEC said nothing to discourage Coinbase, and XRP was listed in February of 2019. So Coinbase, also a very good indication. They're one of the heavy hitters in terms of crypto exchanges in the United States. The SEC did not even give them any indication that XRP or that they could be sued or that they could be charged if they were to list XRP. John Deaton continues, January 1st, 2020, Baylard Inc., a financial investment firm, filed an ethics declaration with the SEC, assuring the SEC that Baylard would only trade digital assets generally accepted in the financial industry as non-securities. And guess what? Baylard decided to list BTC, Ethereum, and XRP. And so here are just some screen grabs just to demonstrate that that was the case. They've even listed it here. They have decided to allow three investments, three cryptocurrencies, Bitcoin, Ethereum, XRP, that are generally accepted to be currencies and are not currently subject to regulation by the SEC. These three cryptocurrencies are treated as non-covered securities. Outside of these cryptocurrencies, investment or other cryptocurrencies is prohibited. Please note the following. So they were even being very careful at that time. and yet the SEC still decided to crack down on XRP and Ripple. And so the tweet thread goes on. So he just summarizes the rest of this. And again, I will link this tweet thread. It's a very informative tweet thread here. I love the Ernest gif. Back up the truck, Vern. That was a terrible Ernest impression. But anyway, I think this does speak volumes. I think John Deaton really does nail it very, very well here in this tweet thread. So what is this LBRY or library document that they're bringing forth? And is it going to have an effect on the case at all? Ripple responds to the SEC. LBRY separately pled a fair notice defense that the SEC did not even ask the court to strike, and which remains pending in the case. The SEC's omission of this fact from its SIR reply application is remarkable. So what is this and how are they going to use it? Fred Rispoli responding on Twitter at FreddyRiz. My thoughts on the request for a surreal reply by the SEC. First, this is getting even more beyond ridiculous. I've never seen this many post-pleading serves ever. This is a tweet thread 1 of 8. Okay, he goes. Second, Judge Torres will probably allow it, but that will allow Ripple to respond as well. So my previous estimate this would be decided likely by March 11th is now being pushed back a minimum of 2 to 3 weeks, which would bring us to roughly around the beginning of April if it is granted. So we are going to get a response by the beginning of April. This is what Fred Rispoli expects. Exceedingly clear the SEC only plan is to delay. So they're grasping at straws. They are looking to delay. Now we can go off on that tangent. Why would they be looking to delay? Why would it be important for them to delay? Well, that's a really good question, isn't it? We can speculate about that all day, I'm sure, and maybe come up with a few different reasons, very, very good reasons why they would. Third, remember your jurisdictions. The LBRY case is in New Hampshire, which is the First Circuit. The SEC versus Ripple case is in New York, which is the second. This is an out-of-circuit sister district court that Judge Torres is even less obligated to consider than a fellow district in the same circuit. So that is another reason why it likely won't fly. Fourth, the judge in the LBRY case was placed on senior status just last year. He had been on the bench for a while, and his opinion was incredibly short and very deferential to the SEC. Also, as an aside, wouldn't you know, LBRY is being represented by none other than Perkins Coie. Fifth, getting to the actual case law, there is a big difference between selective enforcement defense and fair notice defense. This is the first thing Ripple will argue. In fact, LBRY did plead a fair notice defense, and the SEC did not move to strike that. So that's interesting. Next, the facts of what LBRY did compared to Ripple are significantly different. So in terms of the case law here, it doesn't sound like either of those things are similar. And even in their selective enforcement defense, the judge states LBRY did not do a good job, stating why the SEC's other enforcement actions can be discounted. Again, haven't read the pleadings, but LBRY either didn't do a good job or the judge glossed over it because he already predetermined the result. So by bringing in this LBRY case, it does sound like it isn't even really that, or rather it's not going to be that beneficial to the SEC's case. For all these reasons, there's so many holes in it. It's so different in a lot of ways. And so it doesn't sound like, and I mean, I'm no lawyer, but it doesn't sound comparatively like it is any good evidence to bring up as case law. That's why we have the lawyers in the space to explain this to us. By contrast, Ripple has detailed why the SEC's previous enforcements are inapplicable. More importantly, and to repeat, LBRY filed a fair notice defense that the SEC chose not to move to dismiss. Very peculiar, almost like it is afraid to. Ultimately, selective enforcement is a very tough defense to win. Lastly, from the timing perspective, this motion was decided in half the time of Ripple's FND fair notice motion, and that is also extremely odd. So, very great breakdown. A lot of kudos and thanks and congratulations, Fred, for breaking that down. Good job. A lot of people really did need that breakdown, and I think it does speak volumes to kind of where we're at as XRP hodlers in this case. I think it is pretty clear that the SEC's goose is cooked. I mean, many celebrities have even come out and said, I do not respect the SEC, and I'm thinking about one in particular, none other than Mr. Elon Musk. Well, Digital Asset Buy posted this. It's a pretty good clip, actually. Listen to this.
Elon Musk accusing the SEC of leaking information from a federal probe, tweeting, quote, "This is just peeling back the first layer of the corruption onion. Stay tuned." Of course, last week I had more choice words for the SEC, Jim, accusing them of trying to thwart his right to free speech.
Yeah, I think that it's just not worth tangling with the SEC. And Elon is doing such a great job. It's just, I mean, I totally understand. I know Mark Cuban at one point tussled with him on a different issue, but they're just not worth picking on. It just doesn't get you anywhere. So, look, I think he's a great man. I mean, it's just my own advice that stay focused. Just stay focused.
It's the same thing to the SEC, by the way, though. I mean, they're doing all these weird potential rulemaking for hedge funds and disclosure.
You know, I'm glad you
it
mentioned
seems weird to me,
there are a lot
given crypto and so many things where we're still waiting.
Yes,
Still waiting.
and a lot of people feel that he's off the reservation.
Yes.
I don't, but he's in common phases. He's really going full bore on a lot of issues that don't really.
Gensler, I know he
Yeah.
is on stuff like these are sophisticated investors in these funds. Why has this become such an obsession?
I think I'm going to have to get to the bottom of that thing because it doesn't make sense.
Whoa, so the panel on CNBC just ripping Gary Gensler a new one. What the heck is going on over there? Is he off the reservation or what? Of course, started this clip with that Elon Musk quote, and I don't have the 60 Minutes clip up here. I love showing that every now and then. No, I do not respect the SEC. Famous quote there from Elon Musk. So what's going to happen, guys? Joseph Hall now coming to the table saying, yeah, they are not going to win this on the merits alone. So they are grasping at straws. And so this is probably why they are bringing out case law, whatever they can find. In this case, the LBRY case or the LBRY case. Please, somebody tell me in the comments how to pronounce it. They're bringing this up, this case law that doesn't really even connect to what their main point is. I think they're losing focus. I think they're grasping at straws. I think the team over there at the SEC, at least they seem very burnt out. So if they do not win on merit alone, will Ripple have to settle or will this go to trial? Will they get everything they want? And what will the price of XRP be once that happens? Will it decouple from the rest of the market? Will it leave all other cryptocurrencies in the dust? And by extension, what will this mean for other cryptocurrencies that are similar to XRP, like XLM? Will we see XLM move similarly to XRP? Interesting questions. Please do tell me in the comments what you guys think, and please subscribe to the channel. Guys, I want to hit 100,000 by the end of the year, so if you are not subscribed, please subscribe to the channel. Like the video if you like the content I'm providing. I always love hearing your comments. See you in the next one, guys.